So it's great to see everybody. So it's Friday, it's September 5th, and it's 4 o'clock. So we switched to our winter schedule. I hope everyone had a great summer. It was a little kind of funky cold there for a while, a little rainy for a while, but now we're kind of back into almost, I guess, Indian summer. And hopefully it stays a little warm for a while. Um, so nibbling around the edges, Governor Murphy signs the amendment. We talked about this back in July. It had been passed by the legislature. I think it was last week. It was signed by Governor Murphy, and it is truly nibbling around the edges. There's nothing, in my opinion, revolutionary here, but we should talk about some of it. But before we get there, I have to make my annoying lawyer announcements of informational purposes only. This is not we're not representing you. This is not legal advice. This is just a seminar to try and raise issue awareness. If you want a lawyer, if you want legal advice, you have to either hire us or hire some other lawyer, and they'll be happy to help you. No information discussed will be confidential. So if you have secrets, don't tell them on this chat room, and don't say things that you don't want the public to hear because it'll go public. Uh, let's see. So we do have dog of the day. We have a really good dog of the day. Not that the other ones aren't awesome too. But this is Dudley. Dudley is a 3-year-old pit bull, American bulldog, Australian cattle dog, mutt mix. Dudley is owned by Kathy Vaccaro, who is the assistant manager over at the club at East Brunswick. She's a manager for assistant manager for Association Advisors, and beautiful, beautiful dog. I have no idea how Kathy found out, the genetic makeup of this dog. Maybe she had him tested. I like the bow tie though. Very cute dog, really, really great dog. So thanks, Kathy, for sending the picture in. And Dudley will be hitting the calendar next year in 2026. I think so, right? Crystal, yep, 2026. So that's good. So before we get into the actual substance of this, I want to give, we got board members on here. It's usually this call, as you know, is usually board members and property managers. We usually don't have masses of people from the membership at large, but of course the membership, hi Diane, the membership at large is welcome to attend, and that's fine. I did want to give you, the managers and board members especially, oh, Joseph's still with us. I'm glad we're making it, Joseph. Some comfort about some of the things that we deal with every day as managers, board members, vendors, et cetera, attorneys. The wackos are not limited to just our communities, right? So if I'm Eagles fan, right? Eagles fan, I'm an Eagles fan. I'm from South Jersey, grew up outside Philly. The dumbest thing ever for those of you who watched the game last night, dumbest thing ever, right? So Dak Prescott, his contract, $240 million, right? $240 million, right? Jalen Carter, his contract, $21 million, really $22 million. And that doesn't count signing bonuses and all that other crazy stuff these fellas get. Awesome, right? That's fantastic, right? So these people apparently need a condo attorney to come out there and mediate, the coin toss, right? Before they start spitting on each other. Lunacy, right? But everyone should be comforted with knowing even multi-bazillionaires who get paid to play sports, which is awesome. I wish I could do that. I can't. I have to go to condo meetings. Have these problems, right? And the post-COVID world, the incivility has gone all the way to the top, from the lowest earners to the highest earners. So take comfort in knowing that the wackiness, unfortunately, is prevailing, and hopefully the wackiness goes away for all of us soon, right? And we, as another famous guy once said, can't we all get along? Really? Can't we all get along? Right? So that would be nice. All that being said, let's talk a little bit about the amendment. So the amendment was signed. It is nibbling around the edges. It's not doing a whole lot for any of us. It's not putting our boards in the position where they don't have to increase their budgets and fund reserves. You still have to increase your budgets and some fund reserves. Not a whole lot of relief. It did clarify some things. So the first point in there is adequate. Adequate means greater than or equal to 0 over the 30-year period of the reserve study. That doesn't mean just the 30 years from the initial reserve study. So Mike and I talked about this before. We've talked about it before on this show. There are people out there arguing, haha, the board can't get an updated reserve study in year 2 or year 4 to make sure that they're never dipping below zero. The board can get an updated reserve study, and it just means that it's adequate if the study never dips below zero. That's adequate funding. And if you're funding that plan, that's fantastic. Okay. So I have seen claims of various members, and I'm involved in a litigation right now in Ocean County, where there are various claims as to the board not funding properly, not getting the right studies, et cetera. But it defines adequate as not less than zero over the 30-year plan that is currently in effect, right? So the association has to fund based on that plan.
Hey, Fran, just to clarify for everybody,
Sure.
in the columns when you get your reserve study, you'll have threshold funding, usually full funding, and then baseline funding. So baseline funding just means that it never dips below zero. So
That's right.
they're actually stating that yes, baseline funding is sufficient.
Yep. So
Just
they
want to
use
clarify
them,
that.
right. They use them interchangeably, baseline funding, or some will say zero base funding. So they're interchangeable. Zero threshold option required. Such a weird thing to put in a law, right? So really what the amendment says is that if the association is going out and getting options, whether it's full funding, threshold funding, or baseline funding, zero funding, uh, zero threshold funding must be included as an option presented to the association's board. Because, and I believe that was in response to a number of engineering companies saying, wait a second, this doesn't make sense. We don't think this gives the association enough cushion or leeway, a zero baseline budget. So we're going to refuse, as an engineering firm, to quote or give a baseline funding model. And as Mike said, what most engineering firms do is they give you the three options: full funding, threshold funding, or the baseline funding. But certain engineering firms are not. What this now says, as amended, is if you're going to give a series of options for a plan for reserve funding, is you must include a baseline funding scenario in that. I don't think that means, even though governments are getting a little crazy right now, I don't think that means that the engineers must do the reserve study. So I think an engineering firm could still say, nope, we don't want your work. I think what the statute basically is saying is, if you're going to do that work, you must give all three options, or at least the option must include a zero threshold funding. There is an 85% option where the association must comply with the plan, but can fund it at 85%. That's counterintuitive, right? You're like, wait a second, they're saying you're locked into this 30-year plan, but then you're going to only fund it at 85%. That's weird. And I think the reason for that is the legislature said, we're going to give these people a little more cushion. The problem with that is it's not so much of a cushion because it can only last for 5 years. And then it has to be, we'll use the term made up, call it made up. Some people don't like to hear me use the word close the gap, but essentially close the gap. And if you're going to do that, the 85% option, and I'm not a fan of it, I wouldn't recommend it, but some associations may be backed into that. You have to provide a notice in 20-point bold font notice. Yeah, that's right, 20. That's how detailed this legislation is. 20-point bold font notice. And the sellers must provide that to the buyers prior to a contract being signed. So all of this, hear this word: liability, 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 right? Because if this isn't done properly and it's funded at 85% and it doesn't go through this process specifically, somebody's going to sue somebody. You see what I'm saying? A buyer is going to buy in and say the association didn't provide my seller with the proper notice, it wasn't properly funded, and my seller didn't give it to me. Oh, and by the way, the realtor should also be liable because the realtor didn't say, here's the form that outlines when this 85% gap is going to be closed, right? So the 85% is an option. I think it's a dangerous option. So I would be very cautious, right? It just puts, in my opinion, more burden administratively on the board, management, realtors, and sellers in terms of exposure and compliance with the notice requirements. If an association were going to do the 85% funding option, I would be inclined to advise the association to not only send that 85% required notice out, obviously speak to your attorneys about that and what it should say. I would send it out to the membership, but I would also probably think about recording it because then it's record notice, right? So then it's record notice so that if somebody is going to purchase and for some reason somebody drops the ball and the seller doesn't produce it, there will be a backup argument that says, well, it was of record at the time, right? So and I don't know if the county clerk would accept it for recording, but I think it may be something worthwhile considering because then at least you have the most recent notice out there on public record, and you could argue that there was constructive notice. Reserve study is required to be updated every 5 years. That was in the original language and it's still there. So it must be updated every 5 years. But again, hear this again, because some members are saying that it only must be updated 5 years. You can update it every 2 years, every 1 year. You can update it because of a special project has been done. You can update it for various reasons, as long as it's reasonable in the board's business judgment. In fact, the reserve study standards, CAI's reserve study standards, if everyone's seen these before, and if you haven't, you can just send us an email and Crystal will send you a copy of CAI's reserve study standards. So the reserve study standards created by CAI New Jersey, which are referenced in the statute, provide a best practices of 3 years. 3 years rather than 5. Best practice 3 years rather than 5. And that's especially important in a time when we have inflation, right? We have inflation, we have tariff risk, where you may see building materials or raw materials that go into the projects that we deal with significantly modifying the replacement and maintenance costs of the items that the associations are required to address, right? Where do we see that? Paving, roofing materials, any type of building materials, right, impacted very heavily by inflation costs. And that will seriously skew your reserve study, okay? So
And
even though, go ahead, Mike.
I was just going to say, just as a practical matter, so everybody's on the same page with this. For example, I just had a community, we just met last night. They just finished about a $550,000 project that was in the reserve study. That project is now done. If they were to redo their reserve study, within the next few months, next year, it would be to their benefit. It would probably reduce their funding obligations because you're now extending that project over the next 30 years. So redoing your reserve study earlier than every 5 years, especially after a big project, should reduce your reserve funding obligations, which is generally speaking a good thing for your members. I think they would appreciate it.
Yeah, thanks, Mike. Sure. So the next point is, should reserve fund, and we talked about this before, but I think it's important to talk about it again. Should reserve funding law enforcement be limited to the DCA and expressly exclude a private right of action? What does that mean? So this, in my opinion, should be about regulatory compliance. Do the right thing, not a basis for liability against board members, management companies, professionals, engineers, architects, lawyers, accountants, etc. The problem is the way it's written right now, it leaves the door open for liability claims and using this as a basis for liability against board members, management companies, etc. So the question is, does that make sense? I think the answer is probably not. And I think it could discourage volunteers from serving on boards, especially once we start seeing more lawsuits come down. As I said, I'm involved in one lawsuit already where an association member has sued the board because of certain issues that are claimed to be issues with the reserve study and other things. But again, even if there is a claim and the claim is successful, number one, what are the damages? And more importantly, who will pay? Right? Who will pay these damages? So let's assume it's not funded properly and there's a damage calculation of $150,000. Who's going to pay that damage claim? right? Is it going to be the association's insurance carrier? I would say probably not, right? Because I don't think the association's insurance carriers could write enough premium to cover insurance, reserve shortfall claims, right? Because the insurance companies would basically be in a position of could be in a position of insuring your reserve funding, right? And that would just be almost limitless liability, right? And then if an association's board, especially in the case where the association's board has received a reserve funding plan, and for whatever reason, whether they thought it couldn't be afforded or the association didn't have proper funding, and a resident says, you knew, board members, you knew we were underfunded. You knew you weren't setting aside the proper money, even though the statute requires it, and you had that reserve study in front of you. Is that gross negligence? Is that a purposeful act that would convey individual liability on board members? I think a plaintiff's attorney would make those arguments, right? I think a plaintiff's attorney would make those arguments. So if I could amend this legislation again, I would limit any type of enforcement to regulatory enforcement compliance, but not provide a basis for a private cause of action, right? So I would insulate the board members, I would insulate management, I would insulate the professionals, but leave it to, for example, the DCA to ensure compliance without a private right of action. Should reserve funding law mandates be limited to maintaining, repairing, and replacing the primary load-bearing systems of the covered building? That language was clarified a little bit with this amendment, which was helpful. It now says that the association is required to properly fund. Before it said with respect to covered buildings. That's been changed a little bit. But still, the question is, should this full funding requirement be limited to structural items rather than, painting, things like that? It's a good question. There was legislation introduced about 6 months ago that tried to amend this law to limit it to just structural items. My understanding is that's pretty much a dead letter. That's not proceeding in the legislature at all. So I don't see that coming. I just think that that will be a continuing issue out there, especially when this real estate market tanks. When this real estate market tanks, right? Because we all know we've been in we'll call it a bull market in real estate for quite some time, right? Say since 2010 or so. It's been a long run. And eventually everyone knows that the economy is generally cyclical. So whether it's next year, the year after, or whatever, at some point, this real estate market will take a dip. And if it does take a dip and people are underwater on their homes, how in the world are they possibly going to fully fund reserve plans, right? How will that happen? Because, we're old enough to have been around in 2008, 9, and 10, and we saw what our receivables looked like at that time. In many associations, we had 20% of the budget as bad debt, and in some communities, we had 20% of the units not paying, right? So if they're not paying and they're in debtor status, they're certainly not going to be able to pay increased reserve funding or special assessments to close the gap in reserve funding. The next question is it as much about transparency, something like providing the total cost of ownership? So many people, when they're talking about whether to buy a car, lease a car, salespeople will say, well, what you need to consider is the total cost of ownership. It's a really nice car, but it's really expensive to maintain. So you should look at the total cost of ownership. If that's the concern in association, what the total cost of ownership will be to live here, is it really a disclosure concept? Should it be a disclosure concept? More so than setting aside all of the money? Because in theory, then association could issue a reserve study and say, compare the reserve study to reality. So then we're doing a notice every year. The association says, we should be here, but for purposes of disclosure, we're only here. So buyer beware or resident beware. If you buy into this community, this is what should be there. This is what's there. And know that there's going to have to be a special assessment, a loan, or a budget increase. So that's a continuing thing to think about. If it's about disclosure, maybe they don't need to fund. They could amend the statute so that you don't have to fund all items, but perhaps just the structural. With that being said, that was pretty quick. I do want to, we have a special guest star today, Kevin Del Rossini. He's in the upper left-hand corner. He's one of our attorneys here. And he just won a huge case. It was in the real estate foreclosure context, but it provides a wonderful benefit in terms of protecting property interests and especially claims for surplus funds at sheriff sales. When there is a debtor to the association and the unit is being foreclosed. So Kevin, that being said, I'm going to turn it right over to Kevin. Go ahead, Kevin.
Thanks, Fran. So this is switching gears entirely here, nothing to do with reserve studies now. We're in the world of collections. So when a property is foreclosed, at the end of the foreclosure case, the property is sold at what we call a sheriff sale. And if anybody's gone to one of these or heard about them, it's a public auction. So the property is sold at this public auction. Anybody can come to the sale and bid on the property. Highest bidder goes home with the property. And so how that works is if somebody in the audience is the highest bidder, the foreclosing plaintiff, the entity or party who brought the foreclosure case, gets paid what they're owed. So just as an example, I foreclose on a property, I'm owed $100,000, say. And at sheriff's sale, the winning bid is $120,000. So what would happen there is I get my $100,000 that I'm owed. And then the remaining $20,000, that's over and above what I'm owed, that's what we call surplus funds. What happens with that money, that surplus funds, is it's actually held by the court. And people who are entitled to apply for those surplus funds can file a motion with the court and try to obtain their slice of the funds. So why that's really important in the association world is, as I'm sure everybody on the call probably knows, associations frequently have liens on property when owners are delinquent in their maintenance fees. And if you have a lien on a property that is foreclosed, if that lien would be wiped out by the foreclosure, so for example, if a first mortgage forecloses on the property, your association lien is going to get wiped out. Now, there's a few different options that we have in those circumstances, but with regard to the surplus funds, the association is entitled to file a motion with the court to try to obtain their slice of those surplus funds. So we're very interested in the sheriff sale context when surplus funds are generated. That's how it's worked for many, many years. Last year, Governor Murphy signed into law a statute that totally altered how sheriff sales work. Most significantly, it allowed certain nonprofit corporations to come in to a sheriff sale and purchase a foreclosed property at a fixed price. It's what we call the upset price. And it's kind of a technical term, but for the sake of simplicity, it's basically what the foreclosing plaintiff is owed. So in my example, I'm owed $100,000. My upset price at sale is going to be $100,000. What this new law did was it allowed certain nonprofits to come to a sheriff sale and buy the foreclosed property at the upset price with no bidding. So there's the public auction component was taken out of the picture. And the end result of that is there's never going to be any surplus funds when that happens, because it's just whatever the foreclosing plaintiff is owed. Foreclosing plaintiff gets their money, nobody else gets anything. In practice, what that means is these nonprofits were able to come in, get foreclosed properties at a bargain, and associations and other people who had some right to the surplus funds, including the prior homeowners who were just kicked out of their home and foreclosed, they were left with nothing. And so what we did last June is we filed a constitutional challenge to this law after we filed a few other parties filed as well across the state. All of those challenges were ultimately joined together and consolidated in a case in Trenton. And that worked its way through the court system for a little over a year, actually. And just last week, we got a ruling from a judge in Trenton that said that statute is unconstitutional, at least as applied to the cases that were joined together in that case. So that's good news for associations across the state. That means that if there's going to be surplus funds generated by a sale and you have liens on the property, you may be able to go after those surplus funds, and that's a potential avenue to get paid if you really don't have many other options and you have this debt that you otherwise probably would not be able to collect on in many cases.
And so what that really, thanks, Kevin, what that is really important to keep in mind is anytime you have a foreclosure in your association, speak to your association counsel about, is there an opportunity to get surplus funds here? And many times associations don't think about that. They don't speak to their association counsel about it. And they just let it go. Oh, it's going to be foreclosed. We're not going to get anything. That's not the case. You want association counsel to do an analysis every time, especially in mortgage foreclosures, but also tax foreclosures. So there, and we don't have to get into this a lot, but there are times in tax foreclosures where I think we should be making arguments that we should force the tax foreclosure to an actual public sale. And we may wind up litigating that issue over the next couple of years. We'll see. The statute doesn't help us a whole lot, but I think the association needs to think about it, issue identification. Hey, if we see a foreclosure, is there an opportunity to get surplus funds? Because as you know, and as I said before, we've had a bull market in the real estate world for the past number of years, and many people, if not the vast majority of people, have equity in their homes. So if they're going to have equity in their homes and they are getting foreclosed, there should be surplus funds. And if the association's owed money, the association should be trying to get a piece of that to satisfy its debt. That all makes sense? Yeah. Okay, good. So we're going to go to the questions real quick. Jason Pavlovich from Colonial Village over in Hillside says, thanks, but nice. Hi, Jason. Thanks for joining us. Diane Dengler, who's been a manager for probably 100 years, probably started out when she was 10 years old, says, can an association get a paper reserve study update if they complete large projects between regular studies? So, let's go back to this. Reserve study standards. I think if you're going to ask questions like that, Diane, I think that's a really good question because you want to save money. But I think you need to take a look at the reserve study standards. And, for those of you who know Mitch Frumpkin, Mitch was intimately involved with all this stuff, including writing, in part, in large part, I would say, the reserve study standards, right? So these reserve study standards and again, we'll send them out if you need them. But on page 5, they go through the different types of reserve studies that are appropriate. So the level 1 is a full study, level 2 is an update, level 3 is an update with no site visit, which I think you're talking about, Diane, would be an update with no site visit. Personally, I'm a fan of getting the engineer out there because if you're going to do an update, if it's a significant, call it a completely large project, significant project, I like the engineers to see what's going on in the field itself. And if you have done a large project, my hope would be, and I know you would do this just from experience working with you, you would have an engineer involved anyway, right? The engineer would be involved in the project. And, Ed, I think, is shaking his head with us. So Ed knows this. If you're going to do a major project, have a professional engineer involved. And I think that engineer would probably perhaps be the same person who would update your reserve study. So in theory, it wouldn't be, and again, I'm not an engineer, so I'm not opining on this, but it wouldn't be a level 3 update. It would be closer probably to a level 2 update where the engineer would be on site checking the field conditions and giving you a real picture of reality. Are the insurance companies excluding coverage for reserve study type suits, considering them negligence on the part of the board, management company, et cetera? So Diane, there are too few suits out there right now, to my knowledge, to really get a handle on what the insurance company's responses are yet. In the case that I have in Ocean County right now, the association's D&O carrier is for the moment defending the board. The thing with that case is, though, at least at the moment, I don't believe the plaintiff is claiming money damages. I think she's looking for an injunction, having the court order certain things to be done or not done. So I think it's a we'll see, a wait and see thing. Mike, you want to go with Alex's question there?
Yep. And right before I address that, just the discussions in the industry with some of the major insurance representatives in the industry in New Jersey here is that things are trending in that direction where it's suggested that in a year or so, they may start excluding coverage for that. So we'll see. So Alex writes, so if our liens are thrown out at a foreclosure sale, why file them? Are we not able to apply for surplus funds anyway? Are we in a better position with the lien? So really good question, Alex. I would suggest there's 3 or 4 or 5 really good and important reasons to file liens against units. The first one, which is probably the most significant, when you file a lien against an owner's unit, you take debt that is unsecured and you secure it against their real estate. And when you do that, it ensures that the individual that has the lien filed against their unit cannot file bankruptcy and wipe out the amount owed to the association. That's reason number one. And what should happen is at the beginning of your fiscal year, liens should be updated, and we should take all of the amounts owed to the association, accelerate it through your end of your fiscal year, incorporate it into a lien, so that in the event the person does file bankruptcy within the next year, you are as protected as you can be. So that's reason one. Reason two, person cannot refinance their unit or sell their unit and convey clear title with the lien on the property. All right, so that's another big reason. Number three is pertaining to the 6-month lien priority. So you may have heard that before. What that means is that in an association, this applies to both condos and homeowner associations, if you file a lien before a bank initiates a foreclosure, the association will be entitled to what's called a 6-month lien priority when the bank eventually does file a foreclosure action and gets to a sheriff's sale. And you get a 6-month lien priority for every single lien that you file. And what that means is that, let's say in year one, we file a lien. Year two, we file a lien. Year three, we file a lien. A bank then starts a foreclosure action. They get to a sheriff's sale. When the unit is sold at the sheriff's sale, the association would be entitled to year 1, 2, and 3. So that would be a total of 6 times 3 would be 18 months of assessments payable to the association by the owner of the property. It stays on the property. It has a superior lien over the mortgage company's lien. So it's called the 6-month lien priority. And you want to file the liens as early as possible because you do need to beat the mortgage company. And then finally, as Kevin was talking about earlier, if we have a lien on the property and the unit is sold at a sheriff's sale and there are excess surplus funds, it certainly strengthens our argument when we have a secured amount that we are seeking to collect from the trust fund unit that's holding these extra funds. Submit our motion, provide proof of the liens, and ask that they turn those amounts over to us. So yes, liens are really important to file. Timely file them as soon as possible, trying to beat the bank's foreclosure. And again, really the number one reason oftentimes is the threat of a bankruptcy. If somebody stops paying you, things are probably trending downward in their world, and bankruptcy could be a possibility. And if you don't have a lien on the unit, you're going to get wiped out.
So I'm going to take a quick one from Diane here, which is a follow-up one early. She says, I mean, in case of a large project being done between regular studies to perhaps lower the required amounts. Again, I think I would have to defer to the engineer on this, and I'm very much in favor of engineers visiting the site, especially if they've already been involved in a major project. Larry Cohen says, what about inflation? Our engineer wanted to add 3% inflation for all 30 years. Let's see, I lost you there for a second. 3% inflation for all 30 years. This increased the annual contribution by 20%. We do a book study every year, and a full study every 3 years. So that's all positive, Larry. The one thing is, and I am not an engineer, so I can't give you feedback on this. In the beginning of this seminar, I thought I saw my friend Mitch Frumpkin. Let me second. If Mitch, who refuses to retire, So for those of you who don't know Mitch Frumpkin is kind of the preeminent authority for reserve studies in New Jersey, if not the country. So Mitch turned his practice, which is KipCon Engineering, over to his son Seth Frumpkin last year. But Mitch can't retire, and he spends his afternoons doing First Friday with Fran, and I really appreciate that. But if Mitch would be willing to, I'd like to hear Mitch comment on the inflation versus interest thing, Mitch.
Yeah, thanks, Fran. As you know, I'd be happy to talk. Um, the reason that I understand exactly if you start adding inflation, it can have a significant impact on your annual contributions, no question about it. Before there were update requirements in New Jersey, we used to consider including the interest inflation because people wouldn't update their studies. I've done a comparison of including inflation, for example, going out to full 30 years, or just updating your study every 3 to 5 years and then including the inflationary amount. They're relatively the same at the end of the day, but if you just include the inflationary effects every 3 to 5 years when you update your studies, then it's a significant less of an impact. So the bottom line is, I don't recommend including inflation at this point, since you have to update it in maximum 5 years anyway.
Yep. Okay. Well, thanks, Mitch. And if you don't mind staying with us just for a little bit, just in case, if you're okay jumping into some other things. So one thing that people have asked me, Mitch, is the kind of the converse of that. What about, do we then include the 4% interest we're getting now on our tiered CDs for our reserve funds?
Another similar question. People used to think that by putting interest and inflation in, they would offset each other. You have to keep in mind, interest is only on the money you've set aside so far. Inflation is on the total replacement costs, so they do not offset each other. The way it's generally done, and the way I recommend it, especially again because you have to update it, is that you set your beginning balance and when you update your study to reflect including the interest you've gained in there or taking it out. But I don't suggest that you include interest in the 30-year projection because it really skews the results.
Okay, great. Thanks, Mitch. So Maddie says, so what happens now at a sheriff's sale, and what about the sheriff's sales that have already taken place with nonprofits getting the house? Tell us, Kevin.
Yeah, sure. Thanks, Madeline. What happens now at a sheriff's sale? As far as I am aware, as of right now, there are not any counties applying that law that I just described earlier, meaning that the nonprofits that were previously entitled to come to the property and purchase, come to the sale and purchase the property outright, they're not allowed to do that anymore. There are other sections of the law that are still in effect, but that portion of the law, as far as I'm aware, is not being applied by any county in the state. As for sales that have already occurred that were purchased by the nonprofits under the statute, those are going to be still in effect. They're not affected by this particular order because the judge ruled that this order is not retroactive, meaning that it only applies to the cases that were involved in that case and moving forward. So sales that happened in the past and were not involved in that case are not affected by this order.
Okay, thanks, Kevin. So Nick Haralambopoulos says, to be in compliance with the law, do you interpret it to be 85% of the annual budgeted reserve fund contribution or 85% of all annual contributions to replacements fund? I.e. budgeted contributions plus working capital contributions allocated to the fund, as well as interest income allocated to the fund. You know, I have thoughts on that, but I think Mitch again would probably be the best. I'm sorry for imposing, Mitch, but you know.
Maybe you could clarify the question again, or just read back the question because
Yeah, I'll read it again
I'm
because
a little confused on what's being asked.
Yeah, it says, to be in compliance with the law, do you interpret it to be 85% of the annual budgeted reserve fund contribution or 85% of all annual contributions to the replacement fund, i.e. budgeted contributions plus working capital contributions allocated to fund, as well as increasing income? So just, I'll tell you my take, Mitch. I think what the 85% means is 85% of what you're required to fund. I don't know that they distinguish where it comes from. You got to fund it.
Yeah, and I have this thing probably by heart, but I have it says specifically that has elected to fund the capital reserve fund at 85% of the funding plan recommended by the association's reserve study. So it's
Mhm.
what is recommended in this study as far as funding per year. That's it.
That's right. So if you break it out into separate, let's say, streams of cash flow, I don't think it impacts what Mitch just said. Your obligation is your obligation. Yep. Jason Pavlovich again. Hi. Hypothetically, what happens if a large percentage of the residents are unable to pay or refuse to pay the maintenance fee post increase, especially in our small association like ours, 52 units? Are we protected from any punitive? Action by New Jersey State, so long as it is not due to association negligence, but rather owner hardship or refusal? Those who don't just get resolved in a week or so. So no, Jason, I don't think there's anything that protects or immunizes the membership or the board or the management company or the professionals, at least at this point, from not funding. You got to fund, and you've probably heard me say this many times. Um, and sometimes people snicker when I say this, but in some ways, an association is a luxury lifestyle in that, as opposed to a non-association scenario, the association assumes all types of responsibility, whether it's reserve funding, maintenance funding, keeping the pool open, hire lifeguards, all those things that a person who's not a member of association has to deal with on their own. So similarly to the person who has to deal with it on their own, these things have to be paid for. And I don't think that, at least at this point, courts are going to give a pass to anyone who says, well, the unit owners just couldn't pay it or refused to pay it. I don't see a court giving anybody a pass at this point. As I said before, in my perfect world, I think it would be nice to see this statute looked at more as a regulatory compliance tool enforced by the DCA rather than a means of trying to shift liability. But that's not the case right now. And unless that ever happens, I think you have to be prepared to face liability for not complying.
Can you please explain the 85% law again? I could maybe just give you the brief overview of it. So it permits an association to fund at 85% of the total amount required in the reserve fund. So let's use $100,000 a year. If your reserve study says the association must fund at $100,000 per year every year, an association can make the decision to say, okay, we're actually going to fund at $85,000 per year. That can last for 5 years, and then you must get caught up. And if you choose to do that, you are required to send a notice in 20-point bold font, which is obnoxiously large on a piece of paper, to all of the unit owners, stating that the board elected to fund at 85%. And it must also be provided to all owners selling their units, and they have to provide it to their buyers. So there's a little bit of a process there, but there is an option to fund less. But before you take that, I would strongly suggest you work with the association's attorney and engineer to walk through the process, make sure you're compliant.
Okay, thanks, Mike. So the next question is, reserve legislation says that HOAs can use anticipated revenues. I don't have that in front of me. It's they have to fund. Can HOAs use existing fund interest revenues and unit sales reserve contributions as part of anticipated revenue? So I would say no, in terms of funding. I think you could probably use it. So you could take that money, right? You can take that money and contribute it to a reserve fund. The problem there is, though, you're required to fund it. So when you say anticipated revenue, how do we know how many association homes are going to sell in 2026, right? We reasonably don't know that. I mean, maybe on average we have 8 or 10, right? So how many of us know, and this has been changing month to month, how many of us know how much interest are we going to pay for sure, receive on our various accounts? And as Mitch highlighted before, those things things like interest aren't always reliable in terms of offsetting each other. And in fact, they generally don't, because whereas interest is what it is on the money that you have, inflation impacts the entire reserve requirements themselves, right? So my interpretation of the law, and this could be litigated, God forbid they ever have a trial on this issue, but my interpretation is no, you need to fund it. You need to fund it as part of the plan. And unless it's unless it's a budgeted stream that is reasonable under the business judgment rule, there's going to be a problem, right? Now, you could argue, and this is an argument, but this could wind up in court too, is it reasonable to anticipate 8 resales per year? That's why lawyers wind up in court. Rose Bell, is that 85% of baseline? So again, Mitch could chime in on this if he wants. It's not 85% of baseline unless your plan is baseline, right? If your plan is full funding, then it's 85% of full funding. If it's a threshold plan, then you've adopted your threshold plan, it's 85% of that plan. It's 85%, correct me if I'm wrong, Mitch, of the plan the association's board has adopted.
Right, absolutely right, but clearly it's intended for associations that have to play catch up. So they're gonna select the baseline or the zero balance, which means that if you go to 85% of that, there will be a special assessment because it's not dropping to zero, it's dropping to below zero. And it also requires you to disclose based on doing that, what the anticipated assessment's gonna be and what year it's gonna occur in.
Yep. So Neville says, can the threshold funding contribution go below 85%? So yes, and Mitch can talk about this a second. We're conflating kind of two concepts there. The 85% doesn't apply at all with respect to the threshold that the association picks, right? The association meets with its professional engineer. They talk about the funding, they talk about the threshold they want. And it could be 0, which is baseline. It could be, when they refer to threshold, usually it's something higher than 0. So 10%, 20%, 25%, et cetera, of the funding, full funding, if you will. And but the 85% is, they're talking about 85% of the plan that you've adopted. So Mitch, can you just explain what threshold funding plans mean?
Brand, you could do reserve studies now. You got it down. It's that's for sure. The threshold is how much above zero you're going to set your minimum amount. So, for example, if you go down to 0, your threshold is 0. If you say I'm going to go down to $100,000, that's your threshold. A lot of people these days look at the minimum threshold being based on a percentage of the total replacement cost of all components. Like you've heard the 5% rule or the 10% rule. So, but the threshold is based on risk factors, based on a number of different things, which is something you should discuss with your reserve provider and management and whoever based on the risk factor. But that's what the threshold is. But keep in mind, full funding, your threshold is full funding. Baseline funding, your threshold is $0. So
Okay.
it's a different, they're different things.
Okay. Thanks, Mitch. So Ben Lambert, I don't know, many of you probably know Ben. Ben's a Greenbaum Rowe alum and a well-known lawyer in the space. Says, hey, what do you think about what would be a remedy for noncompliance on the regulatory side of things? So, I just speculating, Ben, brainstorming, and Ben and I have been co-counsel in various associations over the years. It could be fines, kind of like the DCA 5-year inspection fines. It could be fines like that. There could be injunctive type relief that the board gets removed for failing to abide. Those types of regulatory things. If I was just, thinking out loud, and Ben, I'm sure you could come up with a bunch of them as well. But I think if we could get to a regulatory compliance model instead of an open-ended liability model, we may avoid a whole bunch of litigation, because I'm very fearful that that we're going to wind up with some significant litigation. Perhaps not. I hope I'm wrong. Let's see.
Frank,
So,
can I just make a quick comment on that, or a thought?
Sure. Go ahead, Mike.
Yeah.
So as a practical
people have
matter,
to remember that Fannie and I'm sorry, go ahead. I'm sorry.
no, that's exactly what I was going to say, Mitch, was as of the practical matter, Fannie Mae and Freddie Mac, that's the hurdle for most associations, not the
Yes.
feds or the state government stepping in, but rather regulatory standards for lending institutions requiring that the associations adhere to the reserve funding law. So if you choose to not fund your reserves, your owners may have a really difficult time obtaining a mortgage.
Right. And so here's the right. If we play that out, I'm Fran McGovern, who wants to sell my unit and retire to Florida. and I want to sell it for a fair market value of 500,000, and I can't because my buyer can't get a mortgage because the board hasn't properly funded reserves. Aren't I suing somebody because I can only get cash buyers now or some wacky kind of financing where they'll only pay my its fair market value is 500 grand, but I can only get 400 grand now. Is my damage 100 grand? I don't know. We're just, we're all just batting this around, but that's my concern, right? And Mike's right, and I think Mitch was going to highlight the same thing, that whether it's a mortgage underwriting issue or an insurance underwriting issue, there are other forces that play into this, right? The mortgage underwriting world is huge in this. The insurance underwriting world is huge in this. But we're going to have to wrestle with this at some time. It's a matter of course, and we'll see how it plays out. But it should be interesting. Mitch, did you want to comment?
That was exactly what I was saying.
Okay.
Fannie and Freddie.
Yeah. All right. Thanks, Mitch. So Jason says, so easy figures, if association has a requirement of $10,000 and has a reserve account of $6,000 in reserves, $2,000 in CTs and $2,000 in operating, is the interpretation that we are actually funded at 100%? No, right? So reserve funds are reserve funds, operating funds are operating funds. Is that what we're talking about? Maybe I didn't understand your question, Jason.
Yeah.
So I'll say, let's try it this way. So if you're going onto the 85% plan and you have adopted, whether it's a full funding plan, a threshold plan, or a baseline plan, you must be funding 85% of that plan with your reserve money, right? You can't mash reserve money and operating money and say that's funded. So I guess, unless I'm misinterpreting your question, Jason, the reserves have to be funded at the 85%. And as Mike said before, you have to go through the whole notice process, et cetera.
And Jason, just to clarify, it's not the underlying balance that matters. It's simply the annual funding that is required. So your reserve study tells you the amount that you must fund annually. That is what's required, not the amount sitting in your account.
Yep. And so Jim Nadart had his hand up for the past 45 minutes. Oh no, he doesn't. Okay, he's just shaking his head. He had his hand up on the Zoom thing, and I thought his arm was going to fall off, but he must have just bumped the button. Thanks, Jim. So that's all the questions we have now. So thanks everyone for turning out. We had a really good turnout today and some awesome questions. And I guess really, really importantly, did Mitch leave? Did he just run out of the room on us?
I was there.
Oh, okay. So thank you so much to Mitch Frumpkin of KipCon Engineering for jumping in with no notice whatsoever and adding color to it and adding some really good comments. Thanks, Mitch. It's great to see everyone. Have a great weekend.